In the early 20th century, bar associations became powerful in terms of shaping the legal profession. The American Bar Association passed a resolution condemning admission without examination. Since then, most states have required the bar exam. What's not commonly known is that prior to that, most states did not require the bar exam. 32 states as well as the District of Columbia offered the diploma privilege. Under the diploma privilege, lawyers could be admitted into the bar without taking a bar examination. It was once the dominant view that graduating from an accredited law institution was sufficient proof of competence to practice law. However, the diploma privilege began a gradual decline as the legal profession became more influenced by bar associations. Currently, Wisconsin is the only state which still offers the diploma privilege. Anyone who graduates from a law school in the state of Wisconsin is admitted into the bar without taking the bar exam. This privilege does not extend to law graduates from out-of-state institutions. Since implementing the diploma privilege, Wisconsin's standards of practice have actually increased. Bar exams have not been an effective safeguard for promoting standards of legal competency. In 2009, state disciplinary agencies reported 125,596 complaints for alleged attorney misconduct. During that same year, the ABA survey on lawyer discipline systems reported that at least 6,769 individuals were privately or publicly sanctioned for misconduct. Keep in mind that these sanctions were imposed against licensed attorneys. That is, 6,769 individuals who had successfully passed the bar exam were sanctioned for improper application of state law and/or court procedure. The American Bar Association has maintained that the purpose of the bar exam is ensure legal competency and not to eliminate competition. However, its own task force found that bar exams do not measure fundamental lawyering skills such as problem solving, factual investigation, and counseling. In the real world, no attorney is required to cite the law precisely without the benefit of consulting written notes. There is absolutely no correlation between the bar exam and one's ability to practice law. After studying the law for 3 years, law graduates have already proven their competency to practice law. There's no legitimate policy basis for requiring the bar exam. Charles Evans Hughes, former Chief Justice of the United States Supreme Court, failed the bar exam 7 times before finally passing. Hillary Clinton also failed the bar exam. There are ample examples of law professors, governors, mayors, attorney generals, as well as congressmen who have failed the bar exam on the first try. These people went on to do great things. Clearly, the bar exam was not an accurate assessment of their competency. Bar exams are fueled by the testing industry, which profits from ripping off those who wish to practice law. There are currently over 88,000 claims alleging that Barbary violated federal antitrust laws by agreeing with Kaplan to prevent competition in the market for bar review courses. Law firms also have a stake in continuing the bar exam requirement. In 2009, there were reported 1,482,271 lawyers with active licenses. Firms are worried that too many lawyers will increase competition. By limiting competition in the legal field, firms are able to charge clients egregious legal fees. Some firms even charge as much as $500 an hour. According to law professor Kevin Hopkins, the public has consistently viewed lawyers as the gatekeepers for access to the law and the courts. However, with legal fees being so unreasonable, 65% of all domestic cases are handled without any legal assistance. The result is that only the wealthy are able to afford fair trials. The bar exam has a disparate impact on racial minorities. Based on a national survey taken in 2002, out of all those who failed the bar exam on the first try, 23% were black, 16% were Hispanic, and 8% were white. Language barriers and foreign culture are both suggested to put immigrants at a huge disadvantage. Out of all Asians who never passed the bar exam, 90% were foreign-born. The socio-economic statuses of law graduates also produce elitist results. Law graduates who never passed the bar exam overwhelmingly came from lower socio-economic backgrounds. As a result of these disparities, the general public has limited access to attorneys, particularly in communities of color. In a true democracy, Laws should be simple enough that any person of average intelligence can understand them. However, judges and lawyers prefer complexity. In the legal profession, complicated doctrines and opinions receive praise while simple doctrines go unnoticed. Bar exams encourage a convoluted legal system because the ability to memorize these complicated doctrines has become the standard of legal competency. All of this is done at the expense of democratic values of transparency and public access. In the past, some have tried to challenge the use of bar exams through the courts. The U.S. Supreme Court has held that there is no federal right to appear before state courts without meeting state bar requirements. In essence, the federal courts have dismissed these challenges because there is no material issue of federal law. However, those cases were argued incorrectly. The issue is not whether one has the right to practice law without being licensed by the state. The real issue is whether citizens have the right to choose whomever they want to represent them. The bar exam deprives millions of citizens of access to competent legal counsel. Under the U.S. Constitution, each citizen is guaranteed the right to counsel. The right to counsel is a fundamental right. This isn't a privilege, such as driver's licenses. Each citizen is entitled to counsel of his or her own choosing. There is nothing in the Constitution that restricts a citizen's choice of counsel to attorneys licensed by the state. State courts have a policy interest in protecting the efficient use of judicial resources. Accordingly, courts are permitted to set minimum standards of competency to practice law. However, bar exams and state licensing requirements go too far. Ultimately, bar exams have to be repealed at the state level. More specifically, bar exams have to be repealed through the state political process and not through the courts. I have personally written letters to legislatures both at the federal and state levels. None of them had the courage to get involved with this issue. By the way, I am going to post a list of these individuals so that you know not to re-elect spineless politicians who are too afraid to do their jobs. I have founded a non-profit called Citizens Against the Bar. You can visit us at citizensagainstthebar.org. You can also find us on Facebook. The goal of the organization is to protect citizens' right to legal counsel. We are educating people about how the bar exam impacts their constitutional right to counsel and ultimately repeal it in 24 states which have the initiative process. We need help with all aspects of the campaign, including fundraising, signature gathering, advertising, and organization. Please let us know if you can lend your support on this matter.